SJC-11138, Commonwealth versus Jesse Camacho.
Good morning. Before you begin, let me say that Justice Hines is not able to be here because she is working for us in Austin at a Access to Justice conference as co-chair of the Access to Justice Commission, but she will be on the panel. So she is not here physically, but she is here for all other purposes. So with that, you may proceed.
Good morning. May it please the Court, Elizabeth Billowitz for Defendant Appellant Jesse Camacho. The fatal shooting in this case took place during a very brief and very chaotic conflict between two groups of men who converged at King Arthur's Lounge in Chelsea. Mr. Camacho was convicted of first-degree murder as to one victim and armed assault with intent to murder and ABDW as to two other victims. At trial, Mr. Camacho did not contest that he fired the shots. Rather, his defense was that he was defending his friend, Mario Sunson, from a sudden collective assault by the opposing group. I'd like to start with the absence of provocation instruction. Consistent with the defense at trial, counsel requested instruction on three theories of manslaughter: defense of another, provocation, and sudden combat. The judge only gave one. He gave defense of another, and his refusal to instruct on the latter two theories was reversible error. I'm going to use the shorthand provocation to refer to both provocation and sudden combat. They're essentially identical on the facts of this case, and this court has treated them as substantially overlapping. A provocation instruction was required, of course, if on any view of the evidence, regardless of credibility, manslaughter could be found, drawing all reasonable inferences in the defendant's favor.
Can I just get some clarity about the sequence of the shootings? Several shots were fired, right?
Correct.
And one was when the victim was upright?
Yes, there were.
And then two more. Was it two more?
When he was prone several seconds later.
And there's not really any argument about that, is there? Or that that it was the defendant who did that?
Correct.
So what I'm having trouble with is how those final two shots are consistent with the theories that you're arguing now.
For a provocation instruction, of course, there's the concept of cooling down. Everything that happened in this case, the entire sequence of shots, took place literally within seconds. And I think when we're reviewing the evidence, looking at the PowerPoint presentations, it's a little easy to lose sight of how quickly this happened when we go through slide by slide and we examine each image and slow it down. It was somewhere between 10 and 13 seconds between the time that the first aggressor, Rodriguez, hit Sunson over the head with a bottle to those final shots. When we're talking about provocation and cooling down, the cases that this court has decided and said provocation was not appropriate because there's no way that a jury could have found that the defendant didn't cool down. Those are situations where we're talking about hours or at the very least minutes. A jury here could certainly find that the defendant that he was provoked and that he did not have the chance to cool down in the 10 to 13 seconds before the final shots. And again, all reasonable inferences need to be taken in favor of Mr. Camacho.
But here you have two hurdles. One is the provocation was not done by the victim. It was, I think, Santiago who hit Sunson with the bottle. And you also, so you have, and the provocation was done against a third party who was not a relative. And are there any cases in which we have said that you are entitled to a provocation instruction when the victim is not the provoker and the provocation is against a third party?
There certainly is a case, at least one, where an attack on a third person provided the basis for reasonable provocation. Carlino did involve a family member.
It was his son, wasn't it?
It was his son.
And wasn't there also some information, some indication that the defendant was coming after, I'm sorry, that the victim was coming after the defendant after he came after the son?
I believe that it was that the instruction was premised on the attack on the son with a knife. Here there was also a potentially deadly weapon in play, a bottle, but perhaps more importantly, the provocation was not just the striking with the bottle, it was the collective assault that happened immediately thereafter. First there was the bottle, and the evidence was conflicting as to whether it struck Sunson on the head or whether it broke nearby. And then there was evidence that somewhere between 4 and 6 additional men then jump on him. There's evidence that there was hitting, that there was kicking. You, of course, raise the issue of whether the victim here was a source of the provocation, and that was the basis on which Judge Brady declined to give the provocation instruction. And he said, I just don't think there's enough evidence that, initially he was inclined to give it. He agreed that these were circumstances that could constitute reasonable provocation, but then he looked at the cases that say that the provocation has to come from the victim and said, I don't think there's enough here. I would submit that that is wrong, and that a close reading of the testimony of the Commonwealth's key witness, Danny Diaz, gives enough here.
So that he would be, you're saying that the victim would have been part of the 4 to 6 others who jumped Sunson?
Correct. And Diaz's testimony, it's admittedly complex, contradictory. However, this court has dealt with situations before where there's recantation, where there's inconsistency, and that's for the jury to decide. If he's telling a couple of different versions of the story, the jury gets to decide which one to believe.
Well, I mean, I read much of his testimony, and I think the best that can be said for you is that he said that the victim came from the place where the fight took place, that he was running from the place where the fight took place. I know there was one statement where he said he was there, which he then later said, no, I did not mean to say that. But it seems as if what is consistent about his testimony and relatively solid is that the victim began to run from the place where the fight took place. That's, I think, what you have.
That is certainly one of the things he says, and he's very consistent on that point. However, he does answer at least twice in the affirmative when he's asked, those 4 or 5 people who are wailing on Sunson, was the person who you saw on the floor one of those people? And he says yes. I think there's a language barrier there. He's testifying through a translator. It is definitely murky. He goes back and forth. He seems to retreat a little from it. But again, when you're taking all inferences in favor of the defendant, I think it was for the jury to decide to credit his testimony. And I would also point out that an inference that the victim, Santiago, was involved in this is supported by Diaz's testimony that this was something planned and that Santiago had had some aggressive words with him earlier in the evening. I think that supports the notion that Santiago is one of the people who was actively involved in this fray.
Okay, so that addresses the one issue of him, whether or not he was among those who were involved in the provocation. Mm-hmm. But then you still have the third party, and I think the best the evidence appears to show is that Sunson was a friend of the defendant.
A close friend, a fellow gang member, as the Commonwealth made much of during this case. I think that provocation is defined broadly enough. I don't think that it just has to be a circumstance that would provoke this response. There's nothing in the law that says it has to be a direct assault on the person or even on a family member. And I would submit that this is a circumstance where the collective assault posed a threat of serious harm to Sunsen, and that the time frame of this collective assault left room for a jury to find that Camacho did not cool down before firing those final shots.
Now, one concern which I have been worrying about as I've been reading this case is, if you are right, what does that open the door to with regard to fellow gang members? I mean, we have so many gang cases and so many instances of violence and retaliation. Do we open the door to the idea that if somebody does something to a fellow gang member and another gang member responds with deadly force, that that person can expect that that will be viewed as manslaughter as opposed to murder?
I think that if there's support, both objective and subjective, that the person was provoked by an assault on another, whether that's a gang member, an innocent bystander, a family member, I think that's for the jury to decide.
And what's the consequence of the fact that this occurred at the King Arthur, which is a place where I think the evidence reveals is full of bouncers? I mean, this is not in the street. This is in a nightclub where security is considerable.
There did not seem to be any evidence here that security was able to intervene and prevent the assault. I mean, again, this all happened incredibly
security
quickly.
can't reasonably prevent somebody from grabbing a bottle and hitting somebody over the
No,
head.
of course not.
But it can
from
respond pretty quickly.
But as far as I recall from the record, they didn't.
Well, I mean, but isn't part of it is that you say it all happened in 20 seconds? I mean, there's the bottle, there's the jumping, and then defendant pulls out a gun and starts shooting. It wasn't really a great deal of time for even good security to be able to respond to take care of that fight. Does that play a role in terms of all this, in terms of whether or not it should be viewed as provocation in that context?
I think the very nature of provocation is that one is responding to a sudden circumstance and is reacting not with any kind of cool calculation, but immediately and from the gut. And in that sense, I actually think that this could have been a better fit for the facts and maybe more persuasive to the jury than the mitigation to manslaughter based on defense of another. For one reason, what we just discussed, the cooling down issue. I think a jury could have found that Camacho no longer needed to use force to defend by the time he delivered those final shots, but could have found, if instructed on provocation, that Camacho had not cooled down. So I think just because the jury rejected defense of another doesn't mean that they would have rejected a provocation provocation theory.
So actually your client also shot one of the security people.
It seems so. There was some, I should mention, there was some evidence. The defense put on one witness who said that
But Mr. Upton was part of the security.
Yes, Mr. Upton was security, but I don't think there's any specific evidence as to,
No, I'm just with this provocation thing. All of a sudden he's shooting everybody in the bar. It seems a little over the top.
But still something that the jury should have been able to consider. And similarly to the Acevedo case, the jury here certainly could have believed that Camacho was reasonably in fear, but that he didn't retreat and he lost the right to use self-defense, or that he didn't have the right to use deadly force. And that would have prevented the jury from either excusing it or mitigating it to manslaughter based on defense of another, but it wouldn't prevent a manslaughter based on reasonable provocation. So failure to instruct on provocation and sudden combat was one reversible error in this case.
Move to the ineffective assistance or closing argument in the time remaining.
Certainly, and I hope I also get a chance to address the adjutant and gang evidence as well, because I feel that those were tremendously prejudicial exclusions that prevented Camacho from being able to support his defense of another defense. Briefly, on ineffective assistance of counsel, the Sixth Amendment, of course, requires the effective assistance of counsel in connection with the defendant's decision as to whether to accept or reject a plea bargain offer. Here, the defendant was consistently interested in a plea. He initiated the plea negotiations, went back and forth several times. His counsel was consistent in his position that manslaughter was the worst he can get. He instructed his client that. His client went along, and Mr. Camacho says that he would have gone along with really anything that his counsel recommended. Unfortunately, his counsel's understanding of the case was severely hampered by his failure to review some critical evidence that the Commonwealth had produced. It appears that he had difficulty opening the files.
Now, I'm very confused by this because it sounds like in the Commonwealth's brief, based on, I haven't read the transcript from the motion for new trial, but they claim that your claim is belied by the record and that during trial, Attorney Davis stated he'd not only seen the security footage, but also the still photographs of each frame of the video, and also testified at the new trial hearing that he reviewed the video prior to trial, and that he'd done that is borne out by his use of it during closing argument. And so I'm not exactly sure what's what.
He did, if we're talking about there's two pieces of video evidence. The security footage, yes, trial counsel says he did eventually look at it, he did use it a bit, but he testified that he didn't see the things that the prosecutor saw, and that he didn't realize.
That didn't mean he didn't prepare, though.
Well, I think if he's not reviewing it with enough diligence, conscientiousness, et cetera, to perceive the exposure to first-degree murder, coupled with the fact that he didn't review the videotape statement of Diaz, who, of course, was an absolutely critical witness to the Commonwealth.
Who looked like he wasn't going to testify until...
It was, it was up in the air, but I would submit that that's not a reason to neglect to review a piece of evidence that effectively provided a preview of the testimony.
Was the videotape interview different than, didn't Mr. Diaz testify in the grand jury?
He did. There was somewhat more detail in the videotape statement, and apparently he was a very compelling witness. The prosecutor had to actually ask defense counsel to review the statement, and he stayed after court the day before Diaz was testifying and made sure that he could review it. The upshot of all of this is that by the time Mr. Davis realized the strength of the Commonwealth's case, it was too late for...
But the videotape wouldn't, at least when I saw it, did not show the two shots fired with him on the ground.
The security footage.
Right. I mean, I didn't.
Correct.
I couldn't tell that he had fired two shots.
No, it was really the combination of that security footage plus Diaz's testimony that provided the exposure to first-degree murder. And had Mr. Davis reviewed that evidence sufficiently beforehand, before trial, in the early stages of trial, when his client was interested in taking a plea, that situation could have ended up differently.
Okay, you're almost out of time, so why don't I ask the question with regard to adjutant?
Please.
Which is where it is quite clear from the evidence, I think undisputed, that the initiation of the use of force by the bottle was done by, I think, was it
Rodriguez?
Rodriguez?
Yes.
Rodriguez initiated by hitting Sunson in or near the head, and that it was also entirely clear that the defendant then pulled out a gun and began firing. Whether or not this is the type of case that adjutant evidence, even under Chambers, would say would be an abuse of discretion for the court to forbid or to knock out.
This is absolutely the type of situation that Chambers instructs adjutant evidence is relevant in. There were many steps here. There were several issues of fact as to the initiation of deadly force. You have the bottle itself. You have when the bottle broke. Was it still a deadly weapon after it broke? You have conflicts of fact in this melee that happens after the breaking of the bottle. There was some evidence that there was kicking, presumably with a shod foot. I don't think anyone was barefoot at King Arthur's. There was some evidence that there were other weapons in play other than the gun. A box cutter is found on the floor. A jury could reasonably infer that based on where it was found, it was somehow involved. There was also some testimony about knives. So there is, I think, plenty of contested evidence as to deadly force that would shed light on Mr. Camacho's use of force, whether he was entitled to any, how much he was entitled to, at what point he was entitled to it. This is precisely what Chambers is useful for, providing the context of each step of this conflict.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. With me this morning is ADA Patrick Hagan, who is the trial prosecutor in this case. We're asking the Court to affirm the defendant's convictions, affirm the denial of his motion for new trial, and affirm the denial of the motion for post-conviction discovery. I'll begin with the provocation instruction, and Judge Brady properly determined that this was not a case where a provocation instruction was warranted. As he ruled, there was no evidence that Santiago, the victim, was the provocateur. And the case law in Massachusetts is clear that in order to get a reasonable provocation instruction, the provocation must come from the victim. Tellingly, I think the only...
Now, I'm sorry, do you agree that if he were among the provokers, that would be sufficient?
Not necessarily. I think Your Honor raises a good point about the provocation going to the striking of a third party.
Okay, but put aside that.
Put aside that.
Let's assume that the person who was actually provoked was the defendant. If it was the defendant who had the bottle knocked over his head or near his head, would it be sufficient to show, okay, he didn't? It was not the victim who had the bottle in hand, but he was among those who may have jumped the person after the bottle was thrown.
Sure. I think under Acevedo, that much would be warranted. In Acevedo, there was actual testimony that the victim in that case was part of the group that surrounded the defendant and was kicking and punching him. There's no such evidence in this case. Not only does Diaz not testify that Santiago was among that group, all he testifies is that he was friends with the group and he saw Santiago running from that general area, which is as you're looking at the stage to the left of it. The video evidence undisputedly shows that Santiago was not part of that incident. I would direct the court's attention to 19 minutes and 59 seconds of the video. That's the last time that you see Santiago until after the shots are fired. At that point, he moves off screen towards the back of the stage. Fast forward 2.5 minutes to 22 minutes and 22 seconds. That's when the fight breaks out. The defendant gets up, pulls out the gun, and starts shooting. It's not until after the defendant is shooting that you see Santiago re-enter the screen from back where the entrance to the stage was, and he's at that point fleeing fully from the defendant. There is nothing to suggest that he was with the group of individuals with whom Rodriguez was congregating right before the bottle is smashed and right after when Sunson tackles Rodriguez to the ground. There's just simply no evidence that Santiago was part of that fight that took place after the bottle smash, just none. And Judge Brady properly recognized that and properly determined because of that, the defendant was not entitled to a provocation instruction.
Okay, let's assume for the sake of argument that we disagree with you on that. So turn to the third-party issue.
I've been unable to find any case that would suggest that the defendant would act based on provocation caused to a third person who at least is not in some sort of relationship, familiar relationship with the defendant. So, for example, in the bowling case, in that case, the provocation to Britt, I believe, was based on their relationship as boyfriend-girlfriend. That just wasn't the case here, and I think Your Honor makes a very important point, which is in a gang case, that would perhaps give a gang member carte blanche to act and not have any recourse for the fact that he was, or he could claim provocation and not have any recourse for his actions other than the manslaughter conviction.
So would you limit this in some way to relatives or,
I think that would be a
close
start.
friends?
I think that there would have to be at least some strong relationship established in the evidence.
Any evidence in this case in the record as to the relationship between the defendant and Sunson?
Yes, they were friends.
Other than that, they were gang members together?
They were friends.
They were friends?
Yes.
Good friends?
I think that they testified at some point they were good friends, yes.
Okay.
I think, quite frankly, this issue is somewhat not ripe for review by this court. It was addressed in a footnote in the defendant's brief. It hasn't been fully briefed. And quite frankly, the court doesn't have to reach the issue given that there was no provocation that came from the victim. I just don't think that this is the case for the court to make that determination. In any event, even if it were, the court should hold that, at least in the facts of this case, the defendant wasn't entitled to the manslaughter instruction, just as Judge Brady determined.
Because he was not among the provokers.
Precisely, Your Honor, precisely.
So, I mean, the problem with identifying the strength of the relationship, as Justice Lank mentions, is one of the problems with gangs is they're like family. So, I mean, it sort of becomes a little bit more complicated to be distinguishing between family and close friends and gang members, given the nature of some of those relationships. So it's a problematic distinction.
I would agree with the court. I would agree. And again, there was testimony that they were friends. They didn't testify that they were family members or like in a family relationship. Contrast that with some of the witnesses' testimony about the victim, and they testified that he was like a brother. There was no similar testimony regarding Camacho and Sunson and Miranda. There just wasn't.
Would you turn to the adjutant issue?
Yes, Your Honor. Simply put, the circumstances of this incident, how it began, the sequence of events, how it ended, were not in dispute. This is not a case where, such as Adjutant or Pring-Wilson or Chambers, where there are differing versions of events. This is not a case where there is a defendant's statement or testimony that is at odds with the Commonwealth's evidence. What the evidence showed and what the parties largely agreed to is that Rodriguez took out a bottle, He started the whole chain of events when he smashed it over the head of Sun Sin. Sun Sin tackled Rodriguez to the ground. A fight ensued. The defendant took out his gun, started shooting. The group that was on the ground and that were in the immediate area all ran out of the bar. Santiago was among that group. He was among the group that was running because of the gun that had been taken out. And he was shot. Because he was shot in the leg, he went down to the ground. And as the defendant ran by or walked by him, he shot him twice in the back.
The Commonwealth made much, I gather, of the gang relationship between and among Camacho, Sun Sin, Miranda, Diaz, right? And I think that it's the defendant's point that this kind of evidence about the Santiago Rodriguez, Thatch, Vazella, Rice group, if the jury would have understood that they were also members of a rival gang, would contextualize sort of the emotions that were, flopping around during this melee and explain it in a different way than if it looks like gang members on one side, one gang member on the other side, as opposed to just two groups. And what's not right about that?
What's not right about that is that there was no evidence that anybody but Rodriguez was a gang member.
Yes, I understand that. But that leads to the next question,
Yes.
which is, why wasn't there evidence? Is it that it doesn't exist?
It doesn't exist, Your Honor. I'd like to run through that, if I may. I don't want to jump ahead to the next issue.
It's your argument.
As far as, let me just say, as far as the adjutant goes, this isn't a case where there are differing versions of events. There was one version, the parties just contested what that version of events meant. This is not a case where I would suggest this court in adjutant envisioned this sort of prior violent act evidence should come in. The jury had the facts before them. They could make their determination based on the facts that were before them, which were largely undisputed. It's just not an adjutant case.
So no need to contextualize is what you're saying.
The contextualization from the gang evidence doesn't exist. And
Well, if it existed, does that make a difference?
not in this case. I don't think it does in this case. And I just want to provide the court, I think the court needs to understand the background of the discovery in this case and the gang evidence that was turned over. The prosecutor turned over discovery as is evidenced by the notices of discovery that are in the record. But he went several steps further. He met with Attorney Davis. They went through the prosecutor's file to ensure that Attorney Davis had everything that the prosecutor had. When Attorney Davis suggested to the prosecutor, it might be helpful if you do an indexed list of everything in your files to make sure that I have everything that you have. The prosecutor did that. When Attorney Davis came into court and filed a motion for gang evidence, the prosecutor said, of course, anything that is in my care, custody, and control that deals with gangs, I can turn over, and I'll go to the Chelsea Police Department. I'll ask them for those reports. He did that. He turned those reports over. On May 7th, the parties are before the court, and Attorney Davis comments to the court that the prosecutor turned over documents related to his gang request up the wazoo, quote. He also said that this prosecutor doesn't hold back on anything. So the prosecutor went the extra step. And it's also important to realize that Attorney Davis tells the court that he wants this gang evidence, but really his whole defense depends on the incident that happened at the Red Roof Inn. And just to remind the court, that's the incident that took place between Rodriguez and Sunson and Miranda a couple months earlier.
Putting him out in his PJs in the cold.
Exactly, and forcing him to walk home. Attorney Davis says, if I can get evidence of that, then I've made my defense. The prosecutor, even though it's not a Chelsea police incident, goes to the Saugus Police Department, looks for a report of that incident, tells Attorney Davis it doesn't exist. Nonetheless, Attorney Davis is able to elicit that evidence at trial. That evidence was important because it provides the context. It provides the context between the hostility between Rodriguez and Sunson and Miranda, which forms the basis for the defense. Rodriguez hits Sunson and Miranda, there's the bad blood there, and because of that, the defendant acts in support of his friends. So there was, simply put, no gang evidence that was not turned over. Now, so to support his argument, the defendant points to two statements. One is a statement that the prosecutor made in the motion for new trial hearing. And in that statement, the prosecutor says, turns out that, or the evidence showed that Rodriguez and his friends were members of the Bloods. They had a dispute with Sunsin and his friends who were members of TRG. The prosecutor then goes on to explain that that night in the club, Rodriguez was there with his friends, and Sunsin and Miranda were there with their friends. It's plain from the record that the prosecutor is talking about two different groups of friends. On the one hand, he's explaining the background that provides the animosity between Rodriguez and Sunsin and Miranda. And when he's saying Rodriguez and his friends, he's talking about his gang member friends. That is taken not verbatim, but almost verbatim from what Sunsin testified to at trial. I would direct the court's attention to volume 6, page 188. What the prosecutor testifies to is almost precisely what Sunsin testified to. So he provides the background to Judge Brady about what the hostility was that existed between Rodriguez and Sunsin and Miranda. He then goes on to explain what happened in the club that night, which was that Rodriguez was there with a separate group of friends that included Santiago, Reese, Vazella, Thatch, but there's no evidence that those individuals were members of a gang. There's just not. That statement has to be taken in context. And I would also point out to the court that at trial, Mario Sunsin testifies that the only member of a gang that was present that night, of a rival gang, was Rodriguez. That's at volume 7, page 44. So that the defendant's proffer based on that statement falls flat. The second statement is a brief reference in a DOC document that says in the DOC's official summary of the event that the victim and his friends were a member of a rival gang to the defendant and his friends. That request was made to the Attorney General's office. It says the source is Suffolk, but it doesn't say it's Suffolk County District Attorney's office. I've put in my brief all of the pleadings that we filed, and it's clear that that version of events in the DOC's version was not copied and pasted from anything that we filed. Simply put, there's just nothing to suggest where that statement came from. Could have come from the defendant, could have come from the Suffolk House of Corrections. It could have been misinterpreted. There's just no evidence to show where that statement came from. And I would also point out that Judge Brady, this was all before Judge Brady and the post-conviction motions, and Judge Brady, as the trial judge, took stock of the defendant's motions, and he denied them. That denial is entitled to substantial deference. So the defendant didn't meet his burden of showing that there was actual gang evidence that existed out there. He also didn't meet his burden of showing that it would have made a difference in this case. He provides an affidavit from Attorney Davis in his motion for new trial, but Attorney Davis doesn't say, I would have tried the case differently had I had this evidence. In fact, by all indications, Attorney Davis was put his defense on as he intended to. He tells the judge on the 10th day of trial that he was able to elicit the gang rivalry, and he was able to present his defense as he thought he was entitled to, or he wanted to. This isn't a case like Murray where there were questions put to the witnesses whether they were gang members. There weren't. It was clear from the record that the people that were with Rodriguez, who he was congregating with right before he hit the Sunsin in the head with the bottle, were friends of his. So it was all out there in front of the jury that there was a rivalry, hostility between Sunsin, Miranda, and Rodriguez. Rodriguez was there with some of his friends. The jury was fully equipped to make their determination based on the evidence that was before them, and there's just no evidence that would suggest that the defendant hasn't met his burden of showing that there was gang evidence that wasn't turned over. If anything, the prosecutor went the extra mile in this case to ensure that Attorney Davis had everything that he wanted and needed, and Attorney Davis consistently told the court that he was satisfied with what the prosecutor had turned over to him. Unless the court would prefer me to start or to turn onto another issue, I'll go to the ineffective issue. And there's a couple different parts to this claim. The first is Diaz's testimony. Attorney Davis was well aware of what Diaz was going to testify to. He had the grand jury minutes. The prosecutor, in moving for a continuance before trial, he laid his cards right on the table. He told Judge Brady, and he provided an affidavit, that Diaz was a crucial witness. He was the only witness who could say that the defendant shot the victim twice as he walked by. Attorney Davis was fully aware of what Diaz was going to say, regardless of whether or not he viewed that particular videotape, which again was consistent with what Diaz testified to in the grand jury. In fact, on the 9th day of trial, before testimony resumes again with Diaz, Attorney Davis tells the judge, Diaz said exactly what I thought and hoped he was going to say. So Attorney Davis was well aware of what Diaz was going to testify to. As far as the video evidence, the surveillance video evidence, it's very clear from the record that Attorney Davis had viewed that video. He says, when he's giving the judge a description of the event and a pretrial date on May 7th, he's describing what happened from the video. He uses it on some points to cross-examine some of the witnesses. He tells the judge that he viewed the video during trial. He testifies again to that.
Do we know if he saw the video, or did he see the individual photographs taken from the video?
Both, Your Honor. Both. And that's clear from the record, because, again, at that pretrial date, he's explaining to Judge Brady what the video shows. And he testifies candidly at the motion for new trial that he viewed the video. What he was saying when the question was put to him, so you're viewing the video for the first time, is that it was at that point during the prosecutor's closing argument that he understood how the prosecutor was going to weave the testimony, the forensics, the medical evidence, the ballistic evidence in with the video to present his case to the jury. It's not a question of Attorney Davis not viewing the video. It's him at that point seeing how the prosecutor was putting his case together to argue that this defendant acted with the intent for first-degree murder and committed that killing with extreme atrocity or cruelty. There's nothing that I've been able to find in the cases that suggests that an attorney is required to foretell precisely how a prosecutor is going to use a piece of evidence in his closing argument. As far as the second-degree plea, it's very clear from the testimony at the motion for new trial hearing, and also during the trial itself, that Attorney Davis was in consultation with his client throughout. Every time that he asked for a manslaughter and the prosecutor came back and said, we can do a second degree, he communicated that to the defendant, and then it was the defendant's decision. And Attorney Davis goes through and he takes great pains to point out that everything that he did was the defendant's decision. He says at page 25 of the motion for new trial hearing that it was the defendant's view that he was acting in defense of his friends. And again, can't discount the fact that until the 7th day of trial, even in the prosecutor's view, this was at best a second-degree murder conviction, more likely a manslaughter, because Diaz hadn't been located and it was unclear at that point whether or not he was going to even testify.
Counsel, one question.
Yes, Your Honor.
Maybe I'm just missing something. Your brief and appendix are impounded?
Based on the fact that there was grand jury testimony.
Oh, that's the basis.
That's it. And the grand jury testimony is separate in a separate impounded appendix, based simply because it's grand jury testimony under the statute.
One last question. You
Yes, Your
say, I think on page 29, perhaps, that in view of the fact that the defendant was 17 at the time, that this matter should be remanded for sentencing?
I think that you have that mistaken with a different case.
Ah.
He was 19 at the time of the murder.
Never mind, different case. Never mind. Okay, thank you.
Thank you very much.